On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
All right, let's get to it. A lot to discuss. And the first one involves a Canadian farmer as he is being ordered to pay more than $60,000 following some confusion over of all things, but it's true, a thumbs up emoji and through a text that he sent in response to a flax buying contract. So walk us through this situation and what the court's ruling was.
Well, what happened in this case, Greg, is that you had a grain terminal that sent a text message out to a group of farmers offering to buy flax for $17 per bushel for delivery later in the year. So this is your standard forward contract type setup. We want to buy your grain, and here's the price we're going to buy it at, and delivery is going to be when you harvest it. And so they set the delivery date for harvest time several months later. The elevator then followed up with some phone conversations with one of those farmers and then sent that farmer a contract for $17 a bushel based on the phone conversations that they followed up with him on for November delivery. Well, the terminal's representative signed the contract in ink and then sent a photo of the contract by text message to the farmer asking for confirmation. And he sent his confirmation. He sent a text message back with a thumbs up emoji. And so when it came for time delivery in the fall, here's the kicker. The price of flax on the market was not $17 per bushel. It was $41 per bushel. And so the farmer is saying, well, wait a minute. I'm not going to sell this for $17 per bushel. I'm going to sell it on the market for $41 per bushel. I didn't have a contract with this fellow. I didn't sign anything. All I sent was a thumbs up emoji. And he claimed, of course, the elevator has to cover that contract, because what these elevators do is they'll turn that, particularly in the United States, they're going to turn it around by selling it on the Board of Trade. So they've got to have commodity come in at the time of delivery. And so that's what happens to the elevator here. We've got to have this grain. They have to go out in the market and buy it at $41 per bushel and then charge the difference between that and the contract price back to the farmer. So it ends up in a lawsuit. And he claimed, wait a minute, I never had a contract with you. All I sent you was a thumbs up emoji to indicate that I got your text message. That did not indicate that we actually had a contract.
So I understand, though, there was a case similar to this. You go back to the 1950s. Now, obviously it was an emoji, but a producer, I understand, ended up selling his farm because of a note he wrote on a restaurant check.
Yeah, just like this case in Canada where the court said, well, based on the fact that you've done this with the elevator a few other times by communicating by text message, you kind of got a course of dealing here, and there was a phone conversation. You went far enough that you've got a valid contract. And so that thumbs up emoji was enough to confirm that there was a contract between those parties. He had to sell that for $17 per bushel, even though the market was at $41. And you're right, back in Virginia, in 1954, there's a case that went to the Virginia Supreme Court. And what it was this one fellow had a farm, and another fellow wanted to buy his farm. And he had talked to him on several occasions over a period of time, wanting to buy that farm. And the farmer would say, no, I'm not selling you the farm. The farm's not for sale. Well, this farmer also had a gas station convenience store along a rural highway. And so this potential buyer stopped in one evening, in fact, on Christmas Eve one day, and sat down with the guy, and they started just haggling over the farm and, of course, drinking while they were doing this. And they were bluffing each other. And the fellow at the farm said, the guy that wanted to buy it said, I've got the money for a down payment. And the farmer said, no, you don't. Stop doing this. You don't have the money to buy my farm. He said, yes, I do. No, you don't. They go back and forth, continuing to drink the whole time while they're doing this. And that's an interesting point in this case I'll get to in a second. And ultimately what happens is that the farmer said, all right, just to get rid of you, I'm going to take a restaurant check and write out on the back that I hereby sell the Ferguson farm to Lucy. The guy's name was Lucy, for stated amount, with deed to be delivered, so forth and so on. He kind of makes it formalized. And Lucy looks at it and said, well, you need your wife to sign that. She's got an interest in this too. And his wife was the cashier, so he takes that restaurant check note that he wrote out up to his wife and said, just sign this. We'll get rid of him. So she signs it. Lo and behold, the court says, you sold your farm for an amount way under market value. So you got to be careful in these types of things, whether it's thumbs up emoji, whether it's just scribbling something out on the back of a restaurant check. And one thing on this emoji case, Greg, even though it was in Canada, we get the same result here in the United States under the National Grain and Feed Association standards and some other areas of law. All you have to have on a forward grain contract is a confirmation, and that. And digital now is just the same as pen and ink. So we have to be very careful with digital communications in forming a contract. It actually can be pretty easy if you've got what the law says is an objective manifestation and a meeting of the mind as to the core contract terms. So that's the point that farmers need to keep in mind.
Yeah, and I guess this can't be emphasized enough. Just go over again what elements legally form a contract, because it's really in the whole crux of this. That's what needs to be people need to be reminded of. Yeah,
that's a good point. There has to be an offer on clearly defined terms. The party making the offer is clear about that, and the party that has to accept the offer, so there has to be an offer and acceptance, must know what they're accepting. And so you've got that's what the law says is there's manifestation, objective manifestation of intent as to the contract terms. So if I know that the terms are I'm selling flax, I'm going to get paid $17 per bushel, delivery is X time, that's going to be enough. Those are the core contract terms. And then we could fill in the details later in terms of how delivery is to occur and those types of things. But the essentials are there. And that's the key. And in this digital age that we're in, acceptance can take just about any reasonable form, and digital is the same as pen and ink. And so that's why we have to be very careful when we're getting into these types of agreements.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program this morning. And we're going to talk about stolen funds in this next case, Roger, because casualty and theft losses important because of the exposure of farm property to the elements as well as exposure to those who might steal. And this is from a couple that got scammed.
Yeah, if you think the first case we talked about was a little bizarre, wait till we talk about this one. And what it involved was a couple that was forced to pay taxes on money that was stolen from them. And this is a result of what Congress has done. So, I spoke with Senator Moran on Friday at the ribbon cutting ceremony at the law school. And if he mentioned that he often listens in, Greg, when he's in town. I don't know if he's still around and can listen in, but this is something that the change in the law that Congress did under the Tax Cuts and Jobs Act that I am sure that neither Senator Moran or Senator Marshall or any other senator at the time thought that this would be the case. But this is unfortunately what happened here. And you can get a deduction for a theft loss. And when we're talking non-business property, the first $100 of either casualty or theft loss that's attributable to each item is not deductible. And then you hit a 10% limit. Your non-business losses are deductible only to the extent your total non-business casualty and theft losses exceed 10% of your adjusted gross income. So once you get over the 10% hurdle, then you can get a deduction. Now, what happened in this case is that you had a couple that were operating a pet food business, and they wanted to retire. They retired from the business back in about 2016 and sold all the business assets or transferred them, basically gave them to their daughter/stepdaughter. And there had been a problem before they had shut the business down with another employee that was setting up some false business accounts and embezzling some funds and those types of things. But that's not directly in play in this case. So they turned their pet food business over to their daughter about a year later, and she's a con artist, and she had scammed other people. And the parents apparently did not know about this. But she caused her parent and step-parent to believe that the former employees had misused the business's credit card processing account to scam customers, and that they should hire legal counsel to protect their rights. So there was some support for mom and dad thinking about that because of the problem with the prior employee that they had fired back in 2014. But their daughter here suggested that they should hire this attorney, and she always acted as the go-between, even setting up a fake email address and posing as the attorney. She forged various legal documents, various business documents, and the parents never asked any questions. And they said, well, initially, you're going to he needs $140,000 to be retained. They said, oh, okay. We'll just dip into our retirement accounts and do that. And so they sent $140,000 to the daughter. And by the time this is all done, they have drained their retirement accounts, their 401ks, their pension plans to a tune of about $1.2 million. Okay? And the Tax Cuts and Jobs Act took effect starting in 2018. They didn't discover this theft until 2019, and a theft loss is deductible in the year of discovery. So it would be a deduction in 2019. But what Congress did was they suspended the theft loss deduction through 2025. So from 2018 to 2025, you can't get a theft loss deduction except if it's related to a casualty, a federally declared disaster area, so certain types of casualties. So you can't get a theft loss deduction for this. And when you withdraw funds from your retirement account, you have to pay tax on them. Now, the only good thing that helped them here was they were at least 59 and a half. They were in their 70s, and so they didn't have to pay the extra 10% penalty on early withdrawal. But the rule is when you take your money out of your retirement account, if it hasn't been taxed, then it gets taxed on the back end, and that's what these types of accounts were, and pension funds. So they had to pay tax on that. So they sued. IRS said, well, you owe about $400,000, a little bit more than $400,000 in additional tax. They paid it, went to district court, and the federal district court said, boy, this is an awfully bad set of facts, but yeah, that's the rule. There's no exception for this. You are the ones that actually withdrew the funds, not your daughter. Had your daughter been the ones that forged your names, did something fraudulent to get the money directly out of your account, you wouldn't have to pay tax on it. But you actually withdrew the funds and then transferred the money to her. Yes, she was defrauding you. Yes, she was stealing all the money from you. Sorry, you're going to have to pay over $400,000 on those stolen funds.
So when you look at or calculate, I guess in this case, the deduction itself, and if you're looking at both the casualty and theft losses, how do you calculate that?
Well, you're always limited to the basis you have in your property that has been stolen or has suffered a casualty. And often in agriculture, we've got low basis equipment or no basis in livestock that perhaps is standing out under the lone tree in western Kansas on your ranch, and they're all killed by lightning. Well, if those are raised cattle, you don't have any basis, so you can't get a deduction for that. Now, maybe there's some, livestock indemnity funds or other types of insurance that can compensate you there, and you always have to reduce any recovery you would get in terms of a theft loss deduction by any recovery you get from insurance. But these rules have been suspended through 2025, so there is no theft loss deduction. There is no casualty loss deduction except in the case of being associated with a federally declared disaster area. Now, again, I would say in this case that's involved here, I am sure nobody in Congress ever anticipated this set of facts. IRS could have exercised discretion and say, this is so bad, this is unjust, we'll exercise discretion here and excuse payment of taxes on the stolen funds. But they sure did not do that in this instance.
Another thing we want to get to, Roger, there was some movement or some news concerning the lesser prairie chicken issue, but in this case by some Kansas farmers.
Yeah, the U.S. Fish and Wildlife Service, it seems like this lesser prairie chicken, Greg, we've been talking about this for 30 years. It never goes away in Kansas. And what the U.S. Fish and Wildlife Service now has done is they've bifurcated the habitat of the lesser prairie chicken and say we've got a northern habitat, a southern habitat. And the rules that we're putting in place on the northern habitat, which Kansas is in, western Kansas is in, are so restrictive that it's going to restrict farming and ranching practices. It's going to put a greater financial burden on counties that have land in these areas that are impacted by this to monitor things, to help the federal government monitor things. And so we've had several Kansas ranchers and counties file suit challenging these rules that the rule was not promulgated properly. And there's another federal law that says that you have to take into account, U.S. Fish and Wildlife Service, when you write these rules under the Endangered Species Act, to consider the economic impact of the rule. And you didn't do that in this instance. So the lawsuit is seeking that the new rule, which took effect last fall, be rescinded and the matter be sent back to the agency to write a new rule consistent with the overriding rules and laws that apply when the agency writes rules under the Endangered Species Act. So they're seeking a remand back to the U.S. Fish and Wildlife Service for the writing of a new rule.
And finally, we got a little time left, but this is quite the program we've had this morning, but talking about the peril of working with family members in this last case.
Yeah, usually in farming and ranching, we think that it's just a great thing to be able to work on the farm or ranch with your family, working together there on what's going to be the legacy that you're going to move on to the next generation. It can be the best job in the world, but it also can create a business culture that might threaten the effective functioning of the whole operation. And what I'm talking about here is that there are some dynamics that have the potential to imperil the business when you're working with family members. You can't fire a family member, at least not very easily, because your family and your business are intertwined. And that can be a problem if you've got somebody that needs to be moved along, and you just can't do that. They also usually don't get feedback, and so that means that the family member doesn't know where they stand, what they're doing well, what could be done better, those types of things. So you can get tension in relationships when family members are working on the farm that wouldn't necessarily be there if it were a non-family member. Well, there was a case out of Nebraska, and give me a few seconds to talk about this one. A case out of Nebraska recently, and it was a grain storage arrangement amongst the family members. As a married couple, they had a blended family. There were 12 children that they raised on the farm. 2 of their sons became farmers, and one of them was renting the farm from his parents. And the other son used the grain bins on the family farm without paying rent. So here's a problem. You got one son that's paying rent, another son that's not paying rent. Things blow up. It becomes an absolute mess. They end up suing each other. It goes to the Nebraska Court of Appeals on the issue of damages and who had to be paid for crops, who had to pay storage fees. And it's just, I won't get into the details of it, but it's just an illustration of, yes, working with family members can be a great thing, but you've got to be careful. Things can go south pretty quickly, and it certainly did in that Nebraska case.
And Roger, as we wrap this up, as always, if they'd like more information, I'd like to read up fully on this, they can go to your blog.
That's right. I posted the case about that we talked about this morning about the stolen funds earlier, and that's going to go to K-State here in just a few minutes to be posted on Ag Manager over there also. But yes, all of these topics can be posted on are posted on my blog. Many of them also go to K-State. My blog can be found at washburnlaw.edu/WALTR. The K-State site is the Ag Manager website.
All right, sounds good. Well, Roger, as always, very much appreciated. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.